Hello, how are you? Hope you are well. My name is Adaka Francis William, and I'm going to help you in this presentation of study and examination techniques in the course Diploma in Public Sector Finance Management. And the course is entitled Legal Aspects of Public Sector Finance and Administration, PFM2. In the table of contents of this course, you have the introduction to legal aspects of public sector finance and administration. You also have constitutional law, an introduction. You also have organs of governance and their functions, the executive, the legislature, as well as the judiciary. Unit 4 talks about the introduction to administrative law. Unit 5 talks about the administrative agencies of government. Unit 6 introduces control of administrative agencies that will be defined. The last unit, which is Unit 7, introduces remedies in judicial review. Other competencies that are expected for a student to sit for this exam includes the following: your understanding of the sources of law, your understanding of the Constitution as a supreme source of the law, as well as the different types of constitutionalism that we have in Zambia. Further, your competence is expected to be tested under the administrative law as well as its distinction with what is called constitutional law. Public administration of these institutions that are going to be identified will also be needed as a competence in an exam. You are also expected to identify and explain the functions that we have in the organs as organs of the government. Also, you are supposed to identify the relevant laws that we have and the regulations that are there in terms of public sector finance. Finally, you're supposed to identify and explain the remedies that are there in the event there is default or there is breach of these laws that are there. So let's run through the units that we have, starting with Unit 1. Introduction to legal aspects of public sector finance and administration. What are the common mistakes that candidates have in the exam? 1, they fail to identify the Constitution as a primary source of law. Remember, each country does have what is called the Constitution to basically be the supreme law of their land. In Zambia, Chapter 1, which is the Constitution, becomes the supreme or the primary law in Zambia or the country. Secondly, students fail to identify the hierarchy of the laws in Zambia, starting from the Constitution, other legislation, customary law, judicial precedents, and other elements that are identified. Further, there is need for students to identify the distinctiveness of law and other social elements. Once you know these things, you will be able to answer competently a question that comes under Unit 1. Why do I say so? In 2019, June 14, question 3 was saying, explain the 3 functions of law in society. So the moment you have identified what a law is, which is embedded in the Constitution, you will be able to clearly answer this question, basically to regulate the functions of what? Society in a given platform. Question 1 of that exam in 2019 said, explain the difference between an Act of Parliament as well as statutory instrument. When you look at the common mistakes that have been identified there, the hierarchy of the laws. So starting from the Constitution, you have what is called other legislation or Acts of Parliament. Under Acts of Parliament, these are laws that are made in Parliament. When Parliament is not sitting, statutory instruments are made outside Parliament. So the distinction here is what was needed. So basically, one of those distinctions is that an Act of Parliament is made in Parliament, while a statutory instrument basically is made by other individuals that are not in Parliament. The same question, when you look at 2, says list any 5 advantages and 5 disadvantages of judicial precedent. A judicial precedent is basically one of the sources of law in Zambia. So once you look at these mistakes that candidates have been making and you read thoroughly under these units, you will be able to answer these questions. What are the commands of ways that have been used? The commands include explain, list, and says with the aid of examples. So with the aid of examples could be case law, or it could be any illustrative example that you may put. When you do that, you will be able to get the sufficient marks that are needed under that unit. Under Unit 2, Constitutional Law, an introduction. What are the common mistakes that we have seen as markers or consultants? Students fail to identify the types or classification of constitution. When you look at your model, you're going to realize that the types of the classification include two: the written constitutions as well as unwritten constitutions. What other common mistakes have we come to find? Students fail to distinguish the sources of law that go to written constitutions as well as unwritten constitution. What are these? What are the other mistakes that we come to see? Students fail to identify how this constitution is basically adopted, because in the adoption of the constitution, there are different types of modes. For example, in Zambia, recently we did look at what is called a referendum. We have what is called National Constituent Assembly, as well as other modes that are used for purposes of adopting the constitution. Now, once a student has identified or has read well under these units, how do we approach the exam? 2019, December 14th, two questions came pertaining to these mistakes that I've identified. Question number 1 says, explain the two classification of the constitution. So basically, written constitution as well as unwritten constitution. So written constitution, they go through the procedures of being written. Unwritten constitution, mostly an example could be Britain, where they just look at customs and other embedded rules and regulations that conduct or curb or regulates the society. Question 2 there was talking about with the aid of examples. Explain the 4 modes of adopting a constitution, and they said in Zambia. So you don't go anywhere else. One of those is a referendum, like I explained. Constituent Assembly is another. Referendum, as explained, was done in Zambia, and we could pick an example from there and explain further as we give reference to the module that you have, which explains the other elements as per the solutions that you may also find. Under Unit 3, we're going to look at the organs of governance. What are these organs? You find the executive, the legislature, as well as the judiciary. Most importantly, what are the common mistakes that students find? The students fail to understand the functions of these 3 organs that have been mentioned. How? They fail to understand the jurisdictions of the courts pertaining to the organs that have been mentioned. Further, the students fail to understand the rationale of what is called separation of powers and another principle which we deem checks and balances. Now, with regards to the organs of government, we did discuss, or we do agree that we have what is called the executive, which basically enforces the laws that are there in a given country. Legislature basically makes the law. However, the judiciary, they come to interpret those laws. Now, these functions are independent of each other. That is why the jurisdiction of the courts, they come in to make sure that these functions are occasioned or are performed separately from the other. What am I talking about? I'm introducing you to what is called the theory of separation of powers. This theory was firstly developed by a man called Aristotle, who further on was joined by another individual called Montesquieu. Now, the theory of separation of powers basically talks about these 3 arms of government should not work in tandem with each other. They should work independent of each other, but work as a check and balance of the other. So the theory or the rationale of separation of powers is that one person should not be found in these 3 organs of governance. Otherwise, if that is to happen, then there will never be an element of checks and balances. What questions came, or what examples can we see? We go back to 2019, June 4th, 14th. What are the 3 organs of government and their functions in the governance of a country? So you just have to basically identify legislature, executive, as well as the judiciary. You're going to get a mark for identifying those 3. Then what are their functions? We already know that, look, when you go into the legislature, it's basically about making the law. When it goes to judiciary, it's basically about interpreting that law. Then when the law has been interpreted, what happens? You go to the executive, which is basically aimed at executing or enforcing that law that has been interpreted. So you see that the 3 arms of government will basically apply using one law, and they are going to work together bringing an element of checks and balances. December 14th, 2018, another question came, and it's saying the separation of powers is a model for the governance of the democratic countries. Under this model, the state is divided into branches, each with a separate and independent power and areas of responsibility. What was the question? Define separation of powers, which you've explained. Basically, these three arms of government should not be together. The process of checks and balances where one independent individual should not be found in all the three. That is the theory of separation of powers. Further, the question is saying, explain the three cardinal theories that spring from separation of powers. What are those theories? Number one organ of government should not perform the functions of another organ. Secondly, an individual should not be found in all these three arms of government. Once that happens, then it's breaching the theory of separation of powers, which is aimed at making checks and balances. Unit 4, Introduction to Administrative Law. What are the common mistakes that we have come to realize? Students fail to understand the difference between administrative law and constitutional law. Remember, constitutional law, as we have already explained, deals with this law, the primary law in a given country that establishes organs and gives them power. It ends there. How does administrative law come in? Administrative law comes to implement, to make sure that the day-to-day functions that have been given by the Constitution are done in a proper manner. That is the distinction. Administrative law looks at regulation. Constitutional law looks at giving the power to an organization. What is another failure or mistake that students have? They fail to understand the parliamentary scrutiny of what is called delegated legislation. Remember, legislation simply means the process of making the law. Now, under legislation, we have what is called parliamentary legislation. These are laws that are made in parliament. Delegated legislation, laws that are made outside parliament. So when those laws are made outside parliament, how does parliament control those laws? The theory is called scrutiny of those delegated legislation. How? Most importantly, these laws do go back to parliaments, and parliaments does have what is called technocrats who look at that delegated legislation. That is the first one. The other mode of control is when these delegated legislation go before the courts of law, and the courts of law are able to control or to regulate those delegated legislation. December 14th, 2019, a question came based on this theory or this topic that we have discussed, and it says, in most states, public law is primarily concerned with the framing of policies and the application of those policies in relation to given cases within the established administrative and legal framework of statutory or constitutional powers. It is about reviewing the modes used in arriving at the decision already made by an authority or an individual public officer. It is also one device which ensures that the rule of law is the same to be accomplished in all government and legislative bodies. What was required? Question 1. List the 2 important public laws in the governance of a country like Zambia. Administrative law, constitutional law. The second one. Discuss the 4 differences between the 2 branches of law identified above. So earlier, I did make an illustration of one of the differences. Administrative law, there's no law, there's no act of parliament that will give you administrative law. But administrative law deals with administering the law that has been given to an agency. Constitutional law, this is the law now that gives or creates an organ as well as giving it power. It ends there. Those are some of the differences that you can look at, but you can also do well by looking at suggested solutions that have been provided on our website.
Take your career prospects to the next level with Zika.
Our diploma in accountancy is an essential qualification if you're planning on entering the accounting profession.
The Zika tax program at both certificate and diploma level equips you with an enhanced understanding of the field of taxation.
Our diploma in public sector financial management is ideal for accountants or trainee accountants working in the public sector.
And CA Zambia, a respected designation designed to ensure that graduates are highly trained to hold senior positions in the workplace.
You can study through flexible options like self-study, as well as part-time or full-time through our accredited tuition providers.
Zika sponsors the top CA Zambia graduate to the One Young World Summit for Young Leaders and also offers scholarships to the top university accountancy graduates from recognized universities.
Visit zika.co.zm now for more information or find us on Facebook and LinkedIn.
Don't delay, your future awaits.
Another question that came under this unit was 2018, December 14th. Explain what administrative law is. Basically, it's a public law that deals with the checking of the day-to-day functions that have been given to an organization or an entity. B, identify at least any 3 sources of administrative law in Zambia. Administrative law, you go back to the constitution, you go back to parliamentary legislation, you go back to judicial precedents. All these embed or contain what are called sources of administrative law. Command words, explain, meaning you give a theoretic understanding of what administrative law is. Identify, meaning you list basically what has been given as a source, and they're saying at least any 3. Unit 5, administrative agencies of government. Now that you've looked at all these units, you come to this unit that is basically telling you about how does now these agencies look at the law that has been given under administrative law as well as constitutional law. Start from the common mistakes. What are these common mistakes? Students fail to understand what amounts to an administrative agency. Students fail to understand the role of these administrative agencies. Students fail to understand how Parliament come in to control these administrative agencies. How do we see, or what do we mean by saying so? What are these administrative agencies? What are these examples of these administrative agencies? So, for example, you can look at Zambia Revenue Authority, which is made or established under Cap 321, which is called the Zambia Revenue Authority Act, as well as another public agency, which is called the Public Procurement Authority, which is made or established under the Public Procurement Authority Act, which is Chapter 309 of the laws of Zambia. Another public agency that you can look at that we have in Zambia is what is called the Road Transport Safety Agency, which is found under the Road Traffic Act of 2002. So these are public agencies that an organ will have for purposes of functioning administrative aims that the Constitution has basically given. So when you look at June 14th, 2019 exam, question number 4, you're going to find a small question which says the transition of governments from UNIP to the MMD in 1991 came with an establishment of government agencies. Identify the government agencies and the acts of parliament they are derived from. And these are the ones that I've just explained. ZRA, Public Procurement Authority, Zambia Privatization Agency, Road Transport Safety Agency. All these are agencies that are used for purposes of governance. C of the same question was saying, what is the rationale of establishing government agencies? So basically, a government cannot work alone. A government will need these agencies to work. For example, ZRA only tasks for purposes of taxing. Anything to do with taxing or tax goes to ZRA. The theory of procurement, one agency, which is the Public Procurement Authority. If you have an issue to do with road safety, there's only one agency, which is the Road Transport Safety Agency. These agencies basically help in the governance of a country, because even the theory of separation of powers is seen because the aims given to these entities are different from each other. Unit 6, control of administrative agencies. Now that you have these agencies, how do you control them? What are the common mistakes that we see? Students fail to understand one major control of administrative agencies called judicial review. Remember, judicial review simply means the process within which a court is basically going to review the decisions made by the executive or parliament. Now, for judicial review to apply, you must note that it can only apply to a public body and not a private body. You cannot apply for judicial review for purposes of a trust. You cannot apply for judicial review for purposes of a political party. Those are not amenable to what is called judicial review. What are other common mistakes that we see? Students fail to understand what is a public body. Students fail to understand, for you to bring judicial review, what happens? You need to have what are called the grounds of judicial review. What are these grounds? Illegality, meaning that the decision made by a public body is illegal. Another ground could be irrationality or Wensbury unreasonableness, meaning the decision made by this entity is okay, but it was made in an irrational mode. At the end of the day, once you put these grounds, you are able to bring forth an action for judicial review. In 2019, June 14th, a question came for purposes of this unit, and it stated, state the test that was established by the courts in the case of R versus City Panel of Takeovers and Majors Ex Parte Data, fine limited in 1987, Queen's Bench 815, to ascertain which bodies would be considered public bodies for purposes of judicial review. For you to answer this question, you have to have an understanding of what amounts to a public body. Can I take a political party, one of the political parties in Zambia, and I go for judicial review? The answer is no. When you look at that case, it does give you what amounts to a public body, so that by the time you are going for judicial review, you are able to ascertain which body is available for that aspect. Another question that we can find was in December 2019. This question was talking about, or it was an explanation, a theory, which I could read, and it says, in Zambia, the Constitution has conferred upon the High Court original and unlimited jurisdiction to hear and determine any issues, including one involving judicial review. There is no limit to these issues, which may be presented before the court for determination. However, this does not mean the powers of the High Court are limitless. What was required? With the aid of examples, discuss the principle of judicial review. And we've agreed. The principle of judicial review is to question whether the decisions that have been made by this public body are okay or not. That's just the theory. So today, you could be interested. If a government entity makes a decision, you have the right as a Zambian citizen to go to court and apply for judicial review, but you must make sure that the body that has made the decision is a public body and not a private body. B was saying, making reference to examples, explain what a public body is for purposes of judicial review. So it is important for you to read this unit and understand public body as well as the case that we've referred to up there, so that you have an understanding of what is judicial review and what grounds or entities are amenable to judicial review. Further, under that case, under that question, you are going to find a question which was saying, list the 3 grounds on which an application for judicial review will be brought before the courts of law in Zambia. So as you go in the courts of law and you are saying this entity, for example, Zambia Revenue Authority has made a wrong decision and I want the court to look at it, to review the decision, you have to have those elements that we've talked about. Amongst them, we said, look, you are going to say it has made an illegal decision. You are going to say it has made an irrational decision. You are going to say it has made an unreasonable decision. Once you establish these elements, the court is able to grant that theory of judicial review. Unit 7, which is the last unit in your module, brings about a theory of remedies. Now that you've gone for judicial review and the court says ZRA has made a wrong decision, what remedies do you have as an applicant before the courts of law? Those remedies are common mistakes that we find in students. What do? First of all, students fail to identify these types of remedies. If you recall or check your module, you're going to find remedies like mandatory order, prohibitory order, quashing order, declaratory orders. These are the types of the remedies that are there. Another mistake that students make is to fail to distinguish these orders that have been made. So to quickly go through them, a mandatory order simply means the court will say ZRA do not do such a thing. Do not make such a decision. That is what is called a mandatory order. An order compelling ZRA not to do something. How about a prohibitory order? A prohibitory order comes from the word prohibiting. It prohibits, it restrains. So for a prohibitory order is likely used at a point when you know that ZRA is about to make a decision. Before they make a decision, you can go and apply for a prohibitory order. How about a quashing order? A quashing order sometimes is called a too late order because a decision has already been made by an entity, but you go to court and say, look, quash this decision so that it will be as if that decision has never been made. Then the last remedy that you have is what is called a declaratory order. Now this one, you just go to court and tell the court, can you declare who is the rightful owner of either this property or what right do I have as an individual? So you just go to court and then the courts will give what is called a declaratory order, an order which enforces or gives about the rights of individuals. Now that we've run through the units, how do you study perfectly and get ready for an exam? Always use the study mode, which is the study kit that you have, the Zika study manual that you have, as well as the kit that is given to you for purposes of your exams. Additional material could be any business law book that you have. Our preference would be Keith and Kenan, which is 8th edition. Further, you need to have a few of past papers that have been written under PFM2 so that you go through them and just see how questions come under that course. As a student is studying for this exam, you have to get organized. You must be paying attention in class if you are one who goes in class. But if you do studies outside, you must stay clear out of distraction. Study in an environment that is conducive for your understanding. If you don't understand, what should you do? You must always ask questions. Ask questions where you don't understand. Why, what, how? These questions will basically help you for purposes of remembering in the exam. Make sure that you have a plan, which is called a study schedule, for purposes of what time is good for you or conducive for you for studies. Review all the notes that you have. Make sure that you put your notes into briefs. Notes could be 40 pages. Reduce them in the notes that you could remember. Remember, the moment you're going to reduce those notes, you are going to reduce them in your mind and able to remember them in the exam. So as you reduce those notes, simplify them into the language or the wording that you're going to have. Some of you would like to have study groups. It is important for you to have study groups because you have an idea of what other people are saying. But remember, only stay in a study group that is conducive, a study group where people are performing, people are contributing. And remember, don't go for a study group that is more than 3 or 4. That is just our opinion. Now, in the exam, what should happen? Basically, an exam is a 3-hour session, and you're given about 15 minutes to read the exam. Read the exams and identify the questions that you have. Unfortunately for you, all the questions are compulsory. But it's okay, because you can isolate within the 15 minutes which questions are easier compared to which questions are hard. Allocate 30 marks for each question and make sure that you keep your time. By 30 minutes, you are done with this question, and at the end of the day, leave the 30 minutes for purposes of reviewing the entire paper of the questions that you have looked at. Sometimes we do give you what are called scenario questions. What is the best approach to approach a scenario question? A theory here is called ISAC or IRAC. What this simply means is that you have to identify the legal issues that are there. After identifying it, you have to state this legal issue that has been identified. And after stating that legal issue, the facts that have been given, apply that legal issue that you are stating to the facts that you've been given. Remember, never should you leave an exam without concluding under the scenario question. So C there means you have to conclude, give your position that you are agreeing in terms of the law that you have stated under that scenario question. One thing you should also remember are the commands that are being used in the exams. When we say explain, it simply means you have to make clear a detailed explanation of what the answer should be. List, state, you have to principally state them in brief. When we say state and you start explaining, you may be losing a mark because the command also gives a mark to a student. Sometimes we may say with the aid of examples, sometimes we may say with the aid of case law, sometimes we can say with reference to the above scenario. All these are commands. With the aid of examples, put an example, put a fictitious example or an example that occurred, or even case law is also allowed for your reference. Where we say with reference to the above scenario, you cannot answer without referring to the above scenario or the scenario that has been cited. Always answer your question constantly referring to the scenario that has been given to you. Remember, you have to study smart, not hard. We have come to the end of this presentation, and if you have any clarification or questions, please don't hesitate to contact the Zambia Institute of Chartered Accountants. Thank you.